If everybody could please mute your computers.
Fresh cup of coffee.
Janae.
Hi.
If everybody could please mute your computers, that would be wonderful.
And the Surgeon General will be sharing more of that information.
Somebody's got their TV on.
Coming up and saying exactly what's happening, because it's really it's very troublesome, I will tell you that. But also to provide clarity on the important point for many Americans on elective surgeries.
Okay, Chuck, can you hear us?
Yes.
Can you hear me? Okay. And can all of you just raise your hand if you can hear Chuck? Say something.
Test. Good.
Okay, awesome.
And Robin, you can mute other people if you're the host.
Yes, I just did.
Oh.
Okay, we're going to get started because we're so appreciative of Chuck giving us his time. So I do want to welcome all of you to our Fieldstone4U webinar. And I'd like to ask that all of you mute your computers at this time. I will just keep monitoring for new participants and I'll mute them as I need to. At the very end, we will open it up to questions. So if you have a specific question, I ask that you wait until the end because you might find that your question has been answered with Chuck's presentation, and send me a private chat and then I will communicate that to Chuck personally, and then he will answer that question. I am recording this, so all of you are aware of that. I want you to know. And then Robin Stropko, my colleague, will get the link and she will email it out to all of you. I am fine with you sharing it with the people that you work with. You know, Fieldstone prides itself on confidentiality, but certainly this is information that I feel very, very important, and I'm happy to share that. But I don't want you to post it on your website or in a blog or anything, but you could share it with people that you know, you work with. I'm fine with that. My name is Robin Sinclair. I work with Robin Stropko, who's also on the call. We're just grateful to people like Chuck who came forward and said that they would like to present on you know, his area of expertise with all of us in these unsettling times. I'm going to let Chuck introduce himself. Again, just want to remind you to mute your screen. Enjoy the presentation. We will have questions and answers at the end. And with no further ado, I'd like to introduce Chuck Keller, who is an employment attorney with Snell and Wilmer, and he is based out of Phoenix. So thank you, Chuck, for agreeing and offering to do this for us. You've got—
My pleasure. Thank you very much. Welcome, everybody.
You've got 22 different people from different organizations in Orange County.
Okay.
So that you're aware.
Well, welcome. Thank you. Thanks for participating. So over the last couple of days, last week, there's been some pretty bleak forecasts from the White House, from medical practitioners, from other epidemiologist type experts, and more employers are now dealing with the complex issue of addressing COVID-19 exposures in the workplace. So what I've done here in this presentation for the next 45 or 50 minutes, I'm going to try to sensitize you to the OSHA issues and try to put into context what you should be doing with respect to the legal risks that would arise with respect to employees or potential third parties exposed as a result of one of your employees being a COVID positive person. So let me just start this with a with an example that will probably make all of you shudder and not be able to sleep at night. So this was one of my first cases in this area about 2+ weeks ago. So I got a call from the director of a nonprofit, and they provide healthcare, direction, counseling, and some medical care to low-income folks. hit one of his caseworkers that not only advises folks and helps them get the requisite insurances and stuff, but also sees them and directs them to potential medical folks. He went to San Diego on February 29th for that weekend. On Sunday, March 1st into Monday morning, he became really sick. Fever, chills, no respiratory conditions, but just fever and chills. So he called out sick. At this point in time, as we're going to talk about later, the employer really wasn't sensitive to checking up on people that were just simply reporting an absence. So his symptoms got progressively worse all day Monday and Tuesday, to the point on Tuesday he felt like he could barely breathe. And he goes to the doctor. The doctor suggests that he has some sort of flu. This gentleman had also had some asthma. The doctor attributed to an asthma. He was educated enough to say, should I be getting this COVID-19 test? And the doctor said no. Plus, there's none really available in the state. No. So his symptoms probably peak late Tuesday evening into Wednesday morning. Based on the prescription that he got, his congestion starts to get better and things like that. And late Thursday night, his fever broke. And while he still felt weak and he still had some wheezing, he comes into work on Friday the 6th. Sunday the 8th is this nonprofit's big fundraiser with all their major donors, the medical people, the doctors, everybody that has helped make this place a success, specifically monetarily. But it was kind of a donors thank you thing and one of their big events of the year. He's there shaking hands with everybody, greeting everybody, interacting with everybody. And feeling much better on the 9th, he goes to work, and on the 10th and the 11th, he is basically involved with some of the younger kids, whether they're in with their parents to be treated or whether they're in, and he just happened to be at that point in time on and off during that day, kind of supervising and checking in on a couple of the teenage volunteers that were kind of manning the little child care area. So we fast that was the 11th and 12th. We fast forward a week later to the 19th, and he gets a call from his friend that, as he very clearly and bluntly said, was intimate with her in the weekend in San Diego, and she's called to tell him that she's COVID-19 positive and was sick. And they kind of compare notes, and they realize that he got the same, had the same kind of symptoms, the same sickness, just like a couple days behind her. So clearly when he saw her during that weekend in late February, she was not necessarily symptomatic, but definitely was positive. So he still hasn't told the company anything. And so he goes on the 20th and tries to get a test himself. Is not successful, but he's pretty focused and determined to get a test. And finally, he gets a test on the late afternoon after work on the 21st. And he's notified Monday morning, the 24th, by the Arizona Department of Health that he's a COVID-19 positive person. He then to his credit, as soon as he got that positive note, comes in and tells the executive director and says, I have COVID-19 positive. I really didn't realize that this was going on, but I've been also told by the healthcare, the Arizona Department of Health, that I have to notify everybody that I was in contact with from the 29th of February through the 13th of March. And they said, well, listen, we'll have to talk about this. Let us get with our human resource folks and let us get with, potentially our lawyers, and, we'll get back to you. And he said, you've got 24 hours. Otherwise, I'm telling everybody at work and the donors on our Facebook page and everybody else that I'm COVID-19 positive. I feel obligated. I somehow dropped the ball. And if you guys don't do it, I will. And lo and behold, that night around 11 o'clock, he sends out a very direct, very transparent, full email to all the employees of the facility, telling them that, he was COVID-19 positive and he was probably in contact with them, and, what to do. And you can imagine the next morning when people are getting up and potentially reading this and coming to work, the poor executive director and the human resource person were flooded with, people coming in and saying, what do I do? What's going on? Why did I get the message? Why did I get the email from the employee as opposed to you? And it was a disaster. So what I'm going to do right now, having just shared that with you, is basically explain to you kind of what you should be doing if you're not already doing it on a proactive perspective, and how to handle a situation somewhat similar to this. So this COVID-19 pandemic has really brought to the forefront OSHA issues. Why? Well, under the OSHA standards, the employer has an obligation to provide a safe workplace free from recognized hazards, and that's the key, free from recognized hazards likely to cause serious bodily harm or death. It's called the General Duty Clause. In California, they enforce the General Duty Clause because there's not a General Duty Clause in Cal OSHA, but they enforce it through the IIPP. And I will get to that here in a little while. The point is, Cal OSHA, Fed OSHA, the CDC have all recognized that COVID-19 is in fact a recognized hazard in the workplace that needs to be addressed by the employer. So what I did probably around, I'm going to say about the 1st of March, a little bit that weekend of the 7th, is I read everything. I read the COVID-19 CDC guidance, I read the Fed OSHA guidance, I read the Cal OSHA guidance, and I read the World Health Care Organization guidance on all this. And I said, we're going to start to get questions about this. What direction are we giving to employers? So having read all that and boiled it down to its bare essence, I came up with this slide presentation, PowerPoint, on what clients need to know and what they need to do. And it's pretty simple. So with that, the publications that I went through included these federal OSHA publications, their guidance on preparing workplaces for COVID-19. And they actually have, if you go to www.osha.gov, they actually have a separate and distinct COVID-19 site that I use just as much as the Cal OSHA site in giving advice and counsel to my California clients. They also have this alert that talks about preventing workplace employee exposures. Cal OSHA also has safety guidance on the coronavirus. It's not nearly as thorough as the Fed OSHA guidance or the CDC guidance, and they rely pretty heavily on the CDC guidance, but it's also pretty good. And then Nevada has a guidance that's specific to the construction industry. And now again, as this moves fairly quickly this week, there are a multitude of different counties, basically the 4 counties in the Bay Area, San Bernardino County, out in the city of LA, the city of San Diego, and I'm probably missing other municipal jurisdictions that have drafted their own guidance that you need to be familiar with. But the real guidance in California is going to be the Cal OSHA guidance. But still, if you're in one of those different municipal jurisdictions, whether it's the city of LA or city of San Diego or San Francisco or one of those counties, and if you need a list of those, please afterwards you feel free to email me and I'll be happy to give them to you. But the importance here is that these guidances are in essence your tools for compliance. So we suggest, as a result of this guidance, that an employer have a infectious disease preparedness response plan. And there's a little footnote here, which I'm going to get to in the next slide, with respect to California. Or you at least take the topics that are covered in this infectious disease preparedness and response plan and integrate it into your IIPP, your injury and illness prevention program. But I'll get that on the next slide. But this infectious disease preparedness and response plan will address all employees that are working together. So if all of your employees happen to be remote, your version of this plan is going to be much more simple and significantly minimized, but you're still going to want to hit some of these major topics. First, on the topics that are covered under this infectious disease preparedness and response plan, you have the identification and the reaction to the virus. And so basically what that's going to curtail is things that I guarantee you are all doing. It has to be work site specific, but it'll be things that include training on personal hygiene, training on and establishing a policy on workplace social distancing, establishing policies on washing hands and potentially wearing respirators or face masks and things like that. So the actions that you are taking in the workplace need to be addressed in here, including, by now what you would think most people would understand, but I ran into a couple employees yesterday in a case that didn't, the signs and symptoms. So understanding the signs and symptoms, encouraging employees to self-monitor. You're also going to address in here what kind of reporting protocol you're going to design if in fact somebody comes to the facility and reports to you that they've been in a common type area in your office or what have you, and they're now COVID-19 positive. Also in this section, I recommend that if in fact you have amended or revised any kind of human resource policies or procedures, whether that's use of sick days or PTO or absenteeisms and unemployment benefits or whatever that might be in the way of policies and procedures, specifically, for example, encouraging employees if they're sick to stay home, things like that, adjusting business travel, developing a telecommunication plan, all of that should be laid out here. So this is in essence identification of and education of your employees to the basics, the signs, the symptoms, proper personal hygiene, things like that, and then reaction in the way of policies and procedures. The next point in this plan is the addressing of employee education and training. So everything you've laid out in bullet point number 1 on the identification and reaction, how are you going to educate your employees of those specific points, whether that's through posters, or whether that's through webinars, or whether that's through emails, or how are you going to do that? Because generally speaking, the all employee meeting obviously is necessarily frowned upon. So how are you going to get this information out to your employees? That should all be laid out in that subsection involving education and training. The next one, this risk hazard assessment, I think is the foundational or fundamental section of this whole plan. Why is that? Because it allows you to understand, as that bullet point says, and assess your risks. And many of your compliance decisions, and also the breadth of this plan, is going to basically not be made in a vacuum, but come out of this risk hazard assessment. And if there's one part of this plan I really see day in and day out that employers are lacking, it's that risk hazard assessment. And I'll talk about that in a minute. And that should also be taken into context with respect to whatever types of personal protective equipment you might be deciding as a result of doing that hazard assessment that you need in the workplace. Last bullet point is workplace controls. So those are divided into engineering type controls, the preferred workplace control of OSHA, and then the administrative controls. And think of it this way: if you can minimize a hazard, in this case, the possibility of those respiratory droplets of the COVID-19 virus in the air by by engineering controls, that's what OSHA wants. Secondarily, they want you to address potentially minimizing the presence of that hazard through administrative controls. And last but not least, if it can't be addressed by either of those two, then it's appropriate to go to personal protective equipment. But by engineering controls, what we're talking about, if you still have people in an office space or building, is potentially looking at with your landlord the changing of your air filters. Can you go to a higher level filter that might actually filter out the respiratory virus droplets? How often is your landlord necessarily changing those? Can your landlord increase the ventilation and the flow of the air in your facility such that you are bringing in significant amounts over a daily basis of fresh air? Do you have a HVAC system where there might be other tenants in the building and they're all sharing that same kind of quote unquote air? That's another thing that you need to look at. And finally, be familiar with whether your HVAC system, because this is a question OSHA asks, is it sucking in new air, and then as it generates that air and circulates that air, is that quote unquote stale air or used air getting kicked out into the environment through some vent on the outside of this building? And so you're constantly bringing in fresh air, or are you more likely in a quote unquote airline type setting where you're circulating continuously necessarily that stale air? So also in the engineering world, and I don't know necessarily how practical this might be for all of you, but I'll throw it out there. Have you installed any kind of physical barrier? So a week and a half, 2 weeks ago, you couldn't probably go into a grocery store or a Starbucks or whatever and see that kind of plexiglass guard up, but now they're everywhere. And that's an engineering control, and it's an engineering control that employers have necessarily adopted. Same thing if you're in a grocery store and you see the stickers down on the bottom of the floor telling you the social distancing upon which they want you to stand. That again is an engineering control. And as I'm going to get to, employers are not doing this necessarily because they are morally driven. That might be, but the real drive on these engineering and administrative controls is potential liability limitations. So on the administrative side, are you minimizing meetings? Have you converted to remote or telecommuting where possible? Have you amended your sick day policy so you incentivize, in essence, the employee to stay home if in fact they're sick? Have you addressed flexible scheduling so that if you need somebody in the office, are you down to a minimum staff? And is that staff not necessarily switching constantly, but are you having somebody in there for basically 1 week and then another person in there for the next week, or the same people working together, so you don't have people coming and going as much as you can prevent it, where there's some potential for cross-contamination. And again, have you looked at enhanced PPE type requirements, and have you modified or in any way significantly upgraded the cleaning and the types of chemicals being used in the cleaning process so they are EPA type approved chemicals that will have the ability to kill the virus when it lands on doorknobs or chairs or desks or what have you. So again, that's things that you should consider under the workplace controls. Cal OSHA now, again, as I said before, you all are required to have a injury and illness prevention program. And any kind of employer, nonprofits as well as for-profit type companies, have to have an injury and illness program. No matter how small your company is, you still have to have one. And Cal OSHA has been really vocal, especially mid last week, about telling employers that their injury and illness prevention plan must address COVID-19 because it's a recognized hazard. They did kind of back off on that a little bit and say, well, you either have the choice of amending your injury and illness prevention plan to address these COVID-19 issues, or you can have an infectious disease preparedness response plan and incorporate that plan into the IIPP. But it better be pretty apparent by reading the IIPP that in some way, shape, or form, it's your disease infection plan has been incorporated into that IIPP. And that can be as simple as a sentence at the beginning, or a highlighted, bolded sentence right at the top saying, that the IIPP has incorporated by reference the the infectious disease plan, and any issues involving COVID-19, please see the infectious disease plan. So that's a way to do that. But it's really important in California because they will cite you for this injury and illness prevention plan not addressing the COVID-19 issues. I just threw this in here in case any of you are servicing in any way, shape, or form any kind of healthcare type industries like my previous client. In California, there is a aerosol transmittable disease Cal OSHA standard that basically hits right on point with what COVID-19 is. It's very limited in its access. It basically applies to what I call the death care industry, whether you're a mortuary or a funeral home or a coroner or something like that, healthcare, medical clinics, that type of thing, where you would expect to see the possible transmission of a infectious disease because the employer there is involved in some sort of medical issues. It could be a laboratory even. So I just put that in there just in case. So let's get to this next bullet point, this what I consider is really the foundation of this whole plan, and that's conducting a risk hazard assessment. So what I did again was went through all of the OSHA guidance and pulled out these different bullet points. So these bullet points are, and I'm going to just go through them so that you'll have a context in which to review this and understand what we're getting at, so that you can do this hazard assessment yourself. So you have to understand and know the community situation which you're situated in as it pertains to COVID-19. So this is very workplace specific. If you have different locations, different offices, it may very well be different for those different offices. And you also need to understand the employees and where you're pulling the employees from that work with you. So it's not just the locale of your business, but it's the locale of the employees upon which you're pulling these folks. So this would be clearly a different risk category, let's say, for example, in Northern California, than very rural Northern California, than Arizona, than Nevada. I put, generally speaking, the high density living areas in California, because of the prominence of the virus, in the high risk category. But you can look at the CDC information, or there's a whole host of other websites that are educating you as to the prominence of the disease in your community. You got to understand that on bullet point number 1. Next, evaluate your business risk. You don't fall necessarily into any category that would put you into a high business risk. Those high business risk employers are going to be the ones that generally fall into that ATD, that special California standard: healthcare, laboratories, mortuaries, first responders, that kind of thing. The one category that you probably do fall into, or could fall into if you've got people coming to work, is that you're working in a dense work environment. So if you have a relatively small office and people are still coming to work there, you could be in that. But for all intensive purposes, I'm going to necessarily put you into that low risk group. The next criteria has to do with assessing your employees and understanding your employee relationships. So this has to do with, do you have an older workforce? Do you have any of your employees that might be in that 65 or over kind of high potential risk category? Number 2, just from the fact that people have been working for you for a while, or they've had absenteeisms unrelated to COVID-19 due to another medical condition or something like that. Do you have people that are in high risk categories? Diabetes, lung disease, heart disease, autoimmune type issues, respiratory type issues, that kind of thing. So you have to understand that workforce as it pertains to that as well. And then understand kind of what I refer to as the home risk factors. Do you have an employee or employees that are going back to their residence, and at their residence there might be a very young person, or their significant other may very well be pregnant, or they have elderly people that they are under their care and living with them, or maybe a child or somebody that has potential respiratory type issues. So you've got to kind of understand that. You don't affirmatively go and ask the employees these kinds of issues, because there's Americans with Disabilities concerns, but you will generally have some understanding, either through employee communications or just casual conversation prior to this outbreak, of whether you have employees that fit within that assessment category or not. And depending on how many you have, you can potentially put yourself into a low, medium, or high risk category. The next bullet point, that fourth bullet point, potential third-party exposures. This is where, in my example, we had some significant issues and some real teeth grinding, because first and foremost, if you're in a work setting where there's just just employees, and one employee comes in and gets another employee sick as a result of the virus, I'm not overtly concerned about that from a litigation legal risk perspective, because those people are employees and they're going to be covered by workers' comp. And in California, there's an exception here. So if in fact an employee is entitled to workers' comp because the injury was quote unquote work related, they got it from another employee, you're again going to be covered by workers' comp unless and in fact that injured employee can prove that your actions in addressing this recognized hazard, COVID-19, fell well below the custom and the practice of the industry. You were not acting, in essence, as a reasonable, good faith employer. So the reasonable employer standard, you fell below that. In that case, if an employee of yours can state that, they can proceed with what's called a serious and willful work comp case, which is totally uninsurable. You can't buy any type of insurance on it. You're on the hook for all of that. And the damages are that employee's total workers' compensation award, which means the time off for pay, the medical bills, and the disability award, if any. Whatever that total is, if they can prove a serious and willful misconduct, you're responsible for writing a check directly to the employee for 50% of that. And again, it's an uninsurable claim. So in California, you've got that specific risk, very unique to California. Last but not least, it is what keeps basically senior management and general counsels and things like that awake at night and with respect to this disease, and that is the potential claim from a third party. So probably right about this time last week, maybe a little earlier in the week, I got a call from a client, and he was the general counsel of a medium-sized company, not a big company, but a medium-sized company. He said, "Chuck, I need to run this by you." And he said, I'm not sure if I'm just being overtly paranoid or what the situation is. But back in our shipping and receiving docks, we have people that load trucks, that unload trucks, and we got trucks coming and going, Federal Express, UPS, delivery folks, and then our normal shipping of our product. I said, okay. So he said, hypothetically, let's assume one of our employees on that shipping and receiving dock comes into work, and he's coming to work because he wants to assure that his job is there because he's heard all these things about COVID-19, and he comes to work the first day with a headache, and that's all he has is relatively a headache. So he's getting through the day, and he comes back the next day, and he hasn't taken his temperature, but he believes he probably has a low-grade fever. I said, okay. And he said, then he calls out sick the next day and says he doesn't feel well, but he calls into our hotline. He doesn't give very much information. And the second day he calls in sick, pursuant to your advice, we follow up with him, and he says, I believe I have the symptoms for COVID-19. Now, whether his doctor sends him to get a test or whether he doesn't have a test, but his doctor has diagnosed him as symptomatic to or made a diagnosis that he has COVID-19, and assuming he's a relatively younger person, 25 to 35, what's he going to do while he's staying home? And I said, well, if he's anything like my college age type kids, he's going to take pictures of how badly he looks, and then he's going to post those all on social media, showing his friends how badly he looks and how badly he feels. And the general counsel literally jumps out of his chair and goes, exactly. And our whole workforce is like that. And he says, on top of it, what's going to happen is when our delivery people come back and for the second or third day, they don't see Joe there. They're going to ask another guy, well, hey, where's Joe? He normally loads my truck. And the guy's going to say, without even thinking about it, well, Joe's not here. He's out with COVID-19. So there gives you some bit of linkage and potential causation. Now let's assume that FedEx guy who comes to our dock at least once, if not twice a day, and he interacts with Joe because Joe's responsibility is help load the FedEx. Now let's assume that FedEx guy a week or two later comes down with COVID-19. And just to make this really morbid, he says, let's assume that the FedEx driver lives with his dearly beloved dad, who's 85 and has just got done recovering from pancreatic cancer surgery, and he brings the disease home. His father gets it. The FedEx guy recovers, but dad dies. Am I going to be suffering from or looking at a wrongful death charge? And I said, absolutely. And he said, I agree with you. But he said, that's what I can't get my senior executives to understand or to believe that that's possible, because they always just say, well, how are they going to prove it? And he said, almost in a sense, it's going to be our job not to prove that it necessarily didn't happen. And I agree with you. Take that on the heels of having a conversation with probably one of the most preeminent personal injury lawyers in the San Francisco Bay Area, who told me this week that since all the courts and everything were down, that he was not very busy, but he was going to take, quote unquote, take it easy and take a vacation. Because he told me, honestly, Chuck, about 9 months from now to 12 to 15 months from now, I think COVID-19 personal injury cases are going to be exploding in the courts. So while you're on the front end of it, I'm necessarily going to be on the back end of it, where a person realizes a year and a half later that they have a lawsuit. And he said, if you don't necessarily think that those late night TV law ads telling you if you've suffered from COVID-19, you might have a personal injury case, aren't going to be prevalent, they're going to be everywhere. And I never had really thought about that until he told me. So again, that bullet point on analyzing third-party potential exposures is really important. Next is to analyze your work environment. Is it an easily controlled and manipulated environment? Do you have people in close contact with each other that might be violating the social distancing? Have you had all the people that you can move to a remote location or telecommuting, that kind of thing? And the last bullet point, which we've already previously discussed, and I'm not going to repeat, is have you analyzed the ability to take workplace controls, those engineering and administrative controls, and where they're feasible and things, are you in essence implementing those and educating your employees on the controls that you're taking? Okay, so once you review all that, you'll understand whether you're in a situation where you're in a medium risk, you're in a low risk, you're in a high risk, and then you can make the rest of these decisions that we're going to talk about on concrete type evidence and things, as opposed to in a vacuum. So that gets to the kind of first criteria or other action items you want to take. If people are actually coming into an office, have you implemented some sort of wellness certification? 3 weeks ago, nobody even knew what a wellness certification was. Probably the early part of 2 weeks ago or over that weekend, this just blew up. And I basically spent almost the better part of one whole week drafting wellness certifications and talking to clients about potential issues and why they wouldn't do it and why they wouldn't do it. And again, 3 weeks ago, there wasn't one construction site that was implementing wellness certifications. Now there's not one that's not. So what are these elements? And again, you can ask 2 or 3 questions. You can ask 10 questions. You can ask these types of questions that I've got laid out here, which are the general ones people ask. and you can determine if people are coming into the office, do you want to physically have somebody there to take their temperature? Are you willing to do the affirmation like you see on bullet point 6 or what have you? So this is really up to you. In my opinion, everybody that has employees that are interacting together at an office or definitely interacting with third parties should be doing some sort of wellness certification of this. I'll just hit a couple of the bullet points. So number 3, I would not ask somebody, have you tested positive for COVID-19? The EEOC kind of frowns on that. They're not necessarily saying it's illegal, but they're saying there's better ways to phrase that question so that you're not point blank asking them necessarily in violation of an Americans disabilities issue. So, and I think the question, have you been tested, is even a better question than have you tested positive, because somebody may very well have just got tested yesterday and they don't have the results back. And if they answer that they've been tested and they don't have their results back, obviously we don't want them anywhere around the work environment. So generally speaking, signs and symptoms the last week. Again, you'll see in the 4th bullet point, signs and symptoms. So I'm not asking anybody if they're presently or have been positive, COVID-19 positive. I'm not asking anybody if they have been around anybody that's experienced signs and symptoms COVID-19 positive. My questions are specifically structured like this, not to run afoul of the EEOC and or the Americans with Disabilities Act. Next one, in the last 2 weeks, I have been, or someone I live with has been under a quarantine for COVID-19. So again, let me just spend a tad bit of time because there's generally a lot of issues about this on the temperature taking. So should you? Totally up to you. You've got to make that decision in coordination with that hazard assessment that you've done. So if you're going to take the temperature, then you've got really 2 ways to do it. One way to do it is actually ask the person, like in bullet point 6, to affirm that they've been taking their temperature and to attest that they have not had a temperature reading in excess of 99.5, or a lot of people put 99.9. So if it's 100 or over, we're not going to have them come to work. Again, that's the flexibility. If I were in a healthcare type of situation, I would be having that number lower than higher. Now, the EEOC has said it's acceptable during the pandemic for you to take every employee's temperature, even though they don't have any signs or symptoms. And more importantly, the EEOC has said that you can bar somebody from basically coming to work if they refuse to have their temperature taken or they refuse to divulge this information. The only thing the EEOC is asking is for you to ask the question, why? So you can potentially elicit whether the person is not wanting to participate in there for some type of religious reasons. Literally, I've had really nobody, refuse. I've had people that have come back amazingly, and maybe I've just had more illnesses than most. Employers call back and say, well, my employee says that they don't have a thermometer, and they've gone to all sorts of different drugstores and convenience stores and grocery stores, and they can't find a thermometer. And one person came in to one of my clients and said, well, I'm happy to take my temperature. I think we have a thermometer at home, but I don't know how to do it. Well, believe it or not, there seems to be guidance on all of this. So there's a beautiful little 2-page handout, and if you want it, just holler for me and I'll send you the link from the World Health Organization on the proper way to take a temperature in the midst of the COVID-19 virus. The only point I want to make here with respect to California is that you have to pay employees to take their temperature. So that's a term and condition of employment. So So you're required to do that. So what a lot of my clients do is once the person's filled out this affirmation, they give them like an extra 15 cents or 15 minutes a day if they're non-exempt to do it. If they're exempt, it's just a non-issue even in California. So moving on. Just a couple of the different issues with respect to the temperatures. One that I forgot, that last one is pretty important. If in fact you're taking people's temperatures and you're physically taking the temperature as the person walks into a facility, and some of my clients are wanting to do that, and that's fine. If you maintain the documentation, if you memorialize what the person's temperature is day in and day out so you can keep track of that, that becomes a medical record. And under Cal OSHA, you have an obligation to retain medical records for 30 years. So my advice here is make sure that they don't have the temperature, whether you're taking it or whether you've hired a third party to take it or whatever. But once they're done, there's no reason to memorialize that temperature taking. They're either in because they don't have a temperature, or you're letting them go home for further communication and things about the potential temperature. Next, you also need to or should be executing some sort of COVID-19 response plan. This is a plan to react to somebody that either has said, I've gone to the doctor and I have signs and symptoms and there's not enough available test kits, so they're telling me just to go home, and if it gets worse, to call back, or they've had a test, or they've had the test and have got the results back and they're positive. If you get that type of a call from an employee, it's really important to go through these steps. And in my opinion, the first two are pretty darn critical. Request the medical information confirming either that positive or negative test from the employee. That is really important. We've had scary stuff come up because employers haven't done that. We had a gal come in and call in and say, I've been gone for 2 days. I'm calling to tell you that I'm COVID-19 positive. Well, my client then went into kind of reaction mode. Later that day, before everybody left, they notified everybody at the retail store she was working at. They told people, if you've had close contact with anybody, in the store, regard that may have shown signs or symptoms, please let us know. They actually reached out and notified people that they knew from interviewing this gal that she had a close contact with. And then they shut the store down for 2 days and completely did a complete deep clean. What happened then was when the company, the third bullet point from the bottom, reported it to their work comp carrier, and their work comp carrier jumped on this to start an investigation to determine if it was work related and wanted to interview her and stuff. She came clean to the work comp people that she really might not have a COVID positive 19 test. Somebody got confused. She was only positive for the flu. And obviously that didn't sit well with the employer, nor did it sit well with some of her co-employees. They had lost 2 days of revenue from the store. Her employees were not very happy. On the flip side of that, we had an employee who had a couple days of absence, younger employee, and the HR people followed up with her, and she said, well, I'm home tending to my elderly father. He has the flu. And they said, well, what kind of flu? And she said, oh, it's not that COVID-19 flu. He just basically has a headache, no fever, some diarrhea, and he's also been throwing up, and he very well could have either the flu or some food poisoning. Well, as we now know, as the CDC develops it, having diarrhea and or nauseousness are other signs, not as prevalent signs, but they're other signs of COVID-19. So she comes back to work, and she works the better part of that full week and calls in Monday and says that she has to call out sick, and she wants to use bereavement leave because grandpa died. And they said, okay, they're still not putting this necessarily together. And she comes back to work on that Wednesday and says, you know, by the way, I was out for these 2 days and arranging some funeral arrangements, and my dad, whose dad it is flying in, but my grandpa was COVID-19 positive. And they said, well, you said he was negative. And she said, well, I might have misunderstood. He had gotten the test at that point and we didn't know, but you know, he was positive. So again, getting that documentation about the positive or negative is very important. Keep in mind, once you get that, it is a medical record. So you've got that 30-year obligation. Then call and interview the employee and try to find out when they were, the first time they were symptomatic, the very first time that they were symptomatic. And once they were symptomatic, were they in the workplace? Were they dealing with employees? Were they dealing with third parties? Were they dealing with donors? What were they doing between the time that they became symptomatic and the time that they isolated or quarantined themselves, and try to get as much information on, you know, if they were in the office, where they were in the office, what did they deal with, what did they touch, and relationships vis-a-vis that close contact with other employees or third parties related to the business. A lot of this other stuff falls into place. You know, we have sent notices, written notices, to pretty much everybody in the workplace that had contact with the employee, just to notify them. I will tell you one thing that I'm relatively surprised about in dealing with this. Now, most employers are asking that COVID-19 person if they can use their name and release their name only to the other employees, only in an internal communication. And when you explain it to the employee that we want to make sure that, you know, we are educating the employees that we're not creating any undue stress or anxiety, and if you weren't in contact with a lot of these people, you know, it would be good to at least let them know who you are, so that a lot of people don't get unnecessarily anxious or nervous. And again, you will get the question if you do it anonymously, well, I have to know who this person is. I have this person at home, or I have this potential illness, or I have this high-risk person that I live with. I need to know. So about 50% of the time, the employee, when approached about this and explained that it's to try to relieve the anxiety and comfort their fellow employees, give consent. In my opinion, that's enough, but just to be sure, I would send an email or a text or something to that person confirming that they've given the consent. Usually that notice goes much better when the people can read it and understand and necessarily know who was the positive person. Next, the last 2 points. You've got an obligation to contact your work comp carrier, and don't think of them as quote unquote the enemy. A lot of times they can provide you assistance in potentially doing an investigation with respect to interviewing the employee, and you might very well figure out while they're COVID-19 positive, but they haven't been to the workplace, it's probably not necessarily work related because their roommate or their husband or their wife was COVID-19 positive, and that's how they got the illness, and then it may not be covered. So work comp, file that claim, and your work comp carrier and claims adjuster and investigator can potentially be helpful. Next, on the OSHA side, unless you're exempt from doing the recording and the reporting, and if you don't know whether you're exempt or not, again, if you fire me an email, I'll be happy to walk you through that. But you should know whether you're on the exempt list or not. If you're not exempt, then you've got to report that COVID-19 workplace positive from the perspective that it's going to be considered to be it's considered to be an illness, and if the employee's lost any time or they've gone to seek medical attention over and above first aid, that triggers this reporting requirement. Now, the reporting requirement or the recording requirement can only take place if it's work related. But the Cal OSHA guidance, as well as the Fed OSHA guidance, claims a COVID-19 exposure can only not be, or only should not be recorded if the employer can prove that the illness resulted solely from non-work related events or exposures. Let me read that again. You have to report a COVID-19 employee positive, assuming that they've either missed days, which is highly likely, or they've received something more than first aid, unless in fact you can prove that the COVID-19 exposure resulted solely from non-work related events or exposures. Very, very high burden for the employer. In most instances, employers are going to have to record it on a 300 log. Everybody, whether you're exempt or not, if an employee is hospitalized, in California, the rule is hospitalized for more than 24 hours. And this is an inpatient hospitalization. Inpatient hospitalization for more than 24 hours for more than just observation or diagnostic purposes, you've got to report it to Cal OSHA. And again, keep that in mind. So if the person goes in and they're COVID-19 positive and they have a medium case and the doctor just wants to be on the safe side, and all they're doing is basically receiving some oxygen, because there's not a whole lot in that type of category that they can do with respect to diagnostic and treating purposes, then you don't have to report it if they're getting something more than observation or diagnostic tests, then you have to report it. If it's just the observation or diagnostic tests, you don't have to. And then finally on this point, determine what kind of additional cleaning, if any, you're going to do and what you're going to do. I will tell you, I hope none of you have to get to this point, but if you do, call me, because there are cleaning companies that are charging $6, $7, $8 a square foot to clean, which is outrageous. And you can get the cleaning done that complies with Cal OSHA and the EPA for, believe it or not, about 10 or 15 cents a square foot. So when you get these quotes at $5, $6, $7 a square foot, it's just ridiculous. So just again, keep that in mind. Next point, once you've got that person, sick person, out of the office, and you've gone through those steps, now you have to look at the various different actions that you're going to potentially take as a result of that, knowing that person is positive. So that situation flows from a variety of different categories. So the first category is going to be that person that's shown signs or symptoms and either has not had a diagnostic test or is awaiting that diagnostic test. And a person that's shown signs or symptoms and, for example, never went and got a test, there's a signs and symptoms way to let them come back to work, or there's a test result way. So if after their signs and symptoms have dissipated and they go get 2 COVID-19 tests within 24 hours of each other and both are negative, then they can literally just come back to work. That's really, really rare, because most people are not, when they're no longer symptomatic, are going to be able to avail themselves of 2 tests. If they have signs and symptoms, then you get into the first category where they have to be fever-free for 3 days. Their respiratory symptoms have to have begun to subside, and it's been at least 7 days since the signs and symptoms were onset to this person. And again, these are CDC, basically OSHA minimums. You can be much more conservative and have the person out. persons had a positive test and had signs and symptoms. There's a different set of criteria for bringing that person back than the person that tested positive and has no signs or symptoms. Same thing, a person that's tested negative, but you may have signs or symptoms, or a person that's tested negative and has no signs or symptoms, you're going to do and address that in a multitude of different ways. That's the employer's option, again, given that risk analysis. So in one of our cases, the person was COVID-19 positive, but no signs or symptoms, and that person wanted to come back to work. But the employer decided to leave them out a full 14 days after the positive test because they happened to share an office with a 65-year-old person who was not in the best of health. So they did that. If a person, the last two categories are not categories that are necessarily addressed by the CDC or OSHA, but you as an employer have a variety of different ways to address this. So no signs and symptoms. They have no signs and symptoms, but they were in direct or close contact with a person that either was symptomatic and diagnosed or was positive. So this is the person that, you know, the employee calls you and says they've been tested positive for COVID-19, and these are the people that I was in direct or close contact with, and you've got to talk to those people and analyze the potential situation with them. And 90% of those people that the person was in direct or close contact with will not be exhibiting signs and symptoms, at least at the time that you're addressing that with them. And again, I want to preface this so that you understand. Direct contact is kind of, in my opinion, gross. It is that the person that had the signs or symptoms, quote unquote, shared their infectious secretions with that employee, i.e. they sneezed on the employee directly, they coughed on the employee directly, something like that when they were in that time period of having the signs or symptoms. That's a direct contact. Again, I haven't had one of those yet. The close contact means that they were within 6 feet of that person in a work environment or a work-related environment for a prolonged period of time. There's no definition of what prolonged is. And again, you have to do this on a case-by-case type of basis. Again, understanding the office setting and your HVAC system and things like that. And under the no signs and symptoms but direct or close contact, there are literally 5 different options that the employer can have. The most conservative is to have the person stay home for 14 days. The most aggressive is to say to the person, we understand you've had no signs or symptoms. We are giving you, physically handing you a list off the CDC website of the signs or symptoms. We want you to sign this acknowledgement that acknowledges that we've given this to you. We've discussed the signs and symptoms with you. We've told you to self-monitor. And if you develop any of the signs or symptoms, we're telling you right now to stay home. But in the event you never develop any of the signs and symptoms we've just gone over with you, you're free to come to work and just self-monitor your health. And as soon as any of that potentially arises, stay home and call human resources. And there's 3 or 4 different options in between the 2 I just discussed. Again, no signs and symptoms, but the person was in the same work area. You're going to have the same 5 options as the direct or close contact, but you're probably going to be much more willing to go with the aggressive approach as opposed to the more conservative approach. So last but not least, there are other OSHA standards that you need to be cognizant about when you are evaluating your workplace. Again, and we talked about all these, so I'm just going to jump through them quick. The record keeping or reporting. You have that record keeping or reporting obligation. Hazard communication. This is coming up quite frequently because what happens, the employer now, pursuant to all the CDC regulations and guidance as well as OSHA guidance, has brought into the workplace a whole bunch of new chemicals, whether that's the Clorox wipes, or whether that's alcohol or bleach to do the cleaning and things like that. You better have the safety data sheets for those chemicals that are being brought in. Even if your independent third-party cleaning company is now switched to these, they are under an obligation to give you those safety data sheets so that you can make them available to the employee. And last but not least, the temperatures and the medical records. Understand positive and negative tests, doctor's report, note to come back. Those are all medical records which you need to maintain for 30 years. So I'm a little bit running a little tad bit long, but I'm happy to field any questions any of you may have.
Chuck, thank you so much.
This was so helpful, Chuck. Thank you so much for sharing all of this. I have a couple questions. Will you be able to email, I'm going to try to mute this. Will you be able to email the deck to me, the PowerPoint presentation and all the links?
Yes, you have a copy of the PowerPoint presentation, correct?
I don't have a link.
Okay, I will email you a copy of the PowerPoint presentation. And for those of you that are a little finicky like me, you will have seen it said closed contact instead of close contact. So I missed that typo, and I will fix that and send that to you, and you can distribute it to all your members.
You get a hall pass on that.
Yeah.
Also, I have a question from one of our participants. Is there a law that states about...
I'm losing you there, Robin.
Okay, hold on. I'll do it closer.
Okay.
Hold on. Can you hear me now?
Yes, perfect.
Okay. Is there a law that states about confidentiality that we are not to reveal the employee's identity?
Yes, the Americans with Disabilities Act and the EEOC said you are legally prohibited from disclosing the employee's identity, personal identity related to a COVID-19 issue, unless and in fact you get their permission.
Okay. Any other questions? Feel free to text me or put it in the chat. Patricia, I think, is the only one that had a couple of questions. The other one was, I think you answered it. If someone is out sick with what seems to be a minor cold or flu, how long do we allow them to be out before they have to return to work? I think you answered.
Yeah, that's a good question. First of all, I'm a big proponent of, if somebody's out sick and they're just calling in, to call them back and follow up on them, and not to ask them, do you have COVID-19, but said, you've been a little bit evasive. I'm calling to see how you're doing. Given this environment, I just want to make sure you're okay. And if they don't volunteer necessarily anything, I wouldn't specifically ask them, do you have COVID-19? If they say, well, I have a fever and I'm having a little hard time breathing, and you recognize all the symptoms, but they necessarily haven't, you can say, well, I think you're showing all the signs and symptoms of COVID-19. I'd like you to go see a medical doctor before you come back to work.
Do you recommend that they email the employee so that there's a record of it?
On the follow-up for the absences?
Yes.
No, I think it's just fine to do that verbally, and depending on your answer, you may want to document that you had that conversation and what the answer was, but I wouldn't feel any obligation to document that between yourself and the employee that called in.
Okay. Are there any other questions from the group? Oh, I have one. If an employee has not been in contact with his coworkers for about 30 days and then becomes sick with suggested symptoms without a test, is this a concern? There is still no contact with coworkers.
If there's been no contact with coworkers for 30 days, I would be fine following your normal return to work procedures. And if you require a doctor's note, you're perfectly fine to do that.
Okay. Thank you. Any
Yeah,
other questions?
and if anybody has any further questions or concerns or wants on any of the documents that I shared here, anything like that, please just get a hold of Robin and she can call me, or you can email me directly, and I'm happy to share any other information with all of you.
Yes, please, unless somebody knows how to figure out who was on this call by email, could everybody who wants,
Otherwise, if not, again, if you need my assistance, please don't hesitate to call Robin and or email me. Otherwise, everybody have, as best we can, a joyous and happy Easter weekend.
Chuck, thank you so much, and I will definitely be in touch.
Okay.
Everybody's giving me a big applause. I think they really appreciate this. So I will
Perfect.
definitely.
Thank you very much.
Okay.
Good luck. Thank you.
send me your email, everybody, if you want this information.
Yeah, so like Robin was starting to say, if any of you have figured out how to send a recording to everybody that was on the call, will you let her know? Because otherwise it looks like the only way she knows is by you emailing her. So if you could email her at her work address, that robins@fieldstoneleadership.org, as opposed to doing it in the Zoom group chat, then she will just follow it up and send it to all of you.
And for the most of you, I've written everybody's names down and I know your email address, but like there's some people on here representing other people like James McNeil, and there's a couple, one just said rec room. You know, if your name wasn't on the screen and you know I don't know you, please email me. Oh, there's James. Okay. Perfect.
And I will I'll do another call in another month, because I'm sure there will be more questions that will come up in another month. But thank you, everybody. Have a wonderful weekend.
Thank
and
you.
I appreciate you jumping on, and stay safe, stay healthy, and stay home.
Bye. Thank you.
Bye.
Hi, everybody.
I'm sending an email to somebody.